Hi there. I don't know how many of you have ever had those Groundhog Day moments where you find yourself saying or repeating the same thing over and over again. And it can be very, very frustrating. And I'm having some of those moments these days around one specific topic. And I thought I'd take this video opportunity to address that topic. And it's having to do with model answers. Now, if you're in our course already, you know that this is truly one of my pet peeves, and that I am not a fan of model answers. As a teacher, I think that they are less valuable than learning to work on your own. In other words, they're a passive form of learning versus an active form of learning. But the Groundhog Day moment that I have most consistently is in conversation either with prospective students or with registered students who say to me, and it doesn't matter what jurisdiction we're talking about now, but say to me, well, what I did or what I plan to do or what I've done in the past is to go to the bar examiner's website or some variant of that. And I've pulled out the old essay questions from prior exams, which is great. And then I've looked at, quote, the model answers produced by the bar examiners in order to understand how to write a successful answer. Now, the logic of doing that is unassailable. It's a great idea. It makes perfect sense. It's what many of you did in law school. You went to your professor's archives in the library. For those of you that are too young to remember, libraries were those big buildings that had books in them. And you then went and looked at their old exams and the sample answers or model answers that the professor provided. And that formed the basis of a lifelong learning structure when it came to testing that said, go look at the model answer and you'll be all right. Unfortunately, it's not a very successful strategy on the bar exam, and it causes people more trouble by a long shot than it resolves. So I thought what I'd do today is to just take a few minutes and explain to you where those answers come from and why they're not very useful in terms of preparing for the bar exam. To do that, we have to go back a number of years. There was a time in the bar exam world when bar questions, essay questions, were not in the public domain. You couldn't get a hold of them. You had to license them or buy them. Now, that's still true when it comes to the National Conference of Bar Examiners and their questions, whether it's on the multi-state bar exam or the performance test or the multi-state essay exam. But generally speaking, the state essay questions were also considered that same restricted airspace, if you will. There was a lawsuit filed, a number of lawsuits filed, to compel the release of these essay questions. Well, the bar examiners as a community nationally, I think were reluctant, and I'm speaking in generalities here. I'm sure there were some bar examiners that thought it was fine. But I would say that in general, the reaction of the bar community was to be very reluctant to release these questions, to put them out in the public domain. Nonetheless, after fairly protracted discussions and negotiations and lawsuits and threatened lawsuits and a lot of discussion and publication, a consent agreement was reached. I think it was in California first, in which the examiners agreed that they would in fact make their former questions available to applicants after the exam. And that time frame varies really from jurisdiction to jurisdiction. Some jurisdictions will let you literally walk out of the exam with their essay questions in hand. That's Florida, for example. Others will make you wait until they release results. Still others delay beyond that. But in any event, virtually every jurisdiction that I'm aware of today makes their questions available in the public domain. All right, so far so good. The questions are available, and if you've taken a bar review course of any comparable integrity, you would know that those questions are contained within that course. Well, what about the answers? And this is where the story got more interesting. Now, I have to admit to you that I'm doing a little bit of backfilling here and trying to understand what occurred and then tell you what I think caused it. But essentially what occurred is that when the answers became available in the public domain, a second problem occurred, which was then, of course, people wanted to see an answer or a passing answer or a model answer. Now, on its face, that all makes sense, but if you've got the sort of warped mind of a lawyer or a law student or, God forbid, a bar examiner, you're not very far away from taking a next step, which is, let's say that you're the bar examiners and you now release the, quote, model answers to these questions, and all of the answers that you release are written in the same format, the same style, the same approach, and they have the same rules of law in them. In other words, they really are modeled in every way. Now, forgetting for a moment the absurdity of doing that, in other words, it wouldn't have really been an answer produced by an applicant under time conditions, but the examiner's producing their own answer, I think you can see how they could create such an answer. And in fact, a bar review course like ours will do some of that. But here's the problem. If the bar examiners released a series of answers to every exam and they all looked alike, they were all written using the same style, whether it was IRAC or the writing style that we teach or something else, and if they all had the same approach, they were roughly the same length, they used the same general rules of law in a topic, it was not impossible to imagine that an unsuccessful applicant could come back to the courts and say, you know what, I saw these model answers and I copied these model answers, and in fact I wrote my answers on the bar exam in precisely the same way. 3 paragraphs, IRAC, whatever it might be. And I failed. And therefore I am suing for admission because I did what the examiner said I needed to do on the essays. Now, I'm not aware of any lawsuit ever contemplated or actually filed that way, but it's not hard to imagine that that would have been a potential difficulty that the examiners were facing. And so, in light of that potential difficulty, the decision was made, in some cases, I think, coherently and clearly designed for this reason, and others, I think maybe they just fell into it, but the decision seemed to have been made to not release answers that were consistent. That is, some of the answers would be written, typewritten, others might have been handwritten. They might use 3 paragraphs, or they might use IRAC, or they might be very lengthy explanations of the law, or they might have shorter explanations of the law and more facts. They might get the law right, or even have conflicting outcomes if 2 answers were submitted to the same question. In other words, the idea was that there would be nothing that you could discern from the model answer that you could take verbatim and put it on the next exam and be any more successful. In other words, I think the examiners were sending the message that model answers are really not very useful or very helpful, but compelled to provide them, okay, you know, sort of in the way that a child grudgingly says, okay, if you're going to make me clean my room, I'll do it, but you know, I'm not going to do a very good job at it. That's what the examiners did. They produced answers. The answers are wildly different. For jurisdictions that release more than one answer to a question, it is a mind-numbing experience if you actually take time and look at the answers. They reach different conclusions almost all the time. They have, in some cases, absolutely incorrect statements of black-letter law contained within them. They are written in all kinds of different styles and approaches. The length of the questions are different. The use of facts, the use of argumentation, wildly different. Now, most examiners, most states will say, we have released answers that got above the average score on this question. And that may be true. I have no reason to doubt it or disbelieve it. But they are not model. Those are the words that are given to them, but they're not model. Even in a jurisdiction that produces an answer written by the examiners themselves later, and there are very few of those out there anymore, they're filled with lots of caveats that this is not the only way to write an answer, it's not the only answer, it's not the only conclusion that can be reached. So here's my point. If you're using those answers to figure out how to write a successful essay, you're going to be in trouble. You can't get enough information from them to really be able to move forward. In other words, you can't take what you learned in the past and push it forward with those kinds of answers. They're not designed for that purpose. They're really designed simply to show you that here are some answers that got better than a passing score or better than an average score in this exam, and that's all they're good for. The problem is that people who are trying to study for the bar exam, particularly in difficult economic times, are looking for ways to cut corners. This is a very dangerous way to cut a corner. It does not pay dividends for you at all. Is it useful to look at past questions? Absolutely. But is it useful to look at past answers? I would say no. Unless you're in a bar review course that has specifically denominated certain answers that they have drafted or edited as being model answers, models of the writing style, models of the law, models of the outcome, whatever it might be in the course you're taking, it is very dangerous to be using that approach. So I hope that you'll consider very strongly how you use model answers if that's your intent, and think very carefully before you begin down that road. It's one that frankly will lead you back into another kind of Groundhog Day, and that's the Groundhog Day when you get the failing notice on the bar exam, and that's not the one we want to see.